Recording has commenced and I'm admitting all.
Okay.
Good morning.
Morning. Has everyone been admitted that is in the queue there, Santiago? Oh, you're muted.
Everyone has been admitted, Ralph, as
Okay.
well as our court reporter and our interpreter when you're ready to make that announcement.
Great. So I guess I'll get started then. Good morning, everyone. This is a meeting of the Agricultural Labor Relations Board is called to order. Please note that all meeting participants and members of the public will need to select the language they prefer to listen to the meeting with. Please look at the bottom of your screen and select the interpretation button in the bottom right. Please click on that and you can select either English or Spanish. If you can hear me now, you need, even if you can hear me now, you need to select the preferred language to ensure you're able to hear the audio for the duration of the meeting. I will give a minute for the interpreter to relay this information. Are we ready?
Were we supposed to hear something?
Yeah, Santiago, we can't
Yeah.
hear you.
I'm looking into it. The interpreter's reporting that she's simultaneously translating, and I just want to confirm with her that the instructions were simultaneously translated into the Spanish channel. Got it. Are you able to repeat that instruction, or do you need to simultaneously interpret now?
Are we supposed to be hearing her?
Right. So if they added Spanish late, are you able to now repeat the instruction, or do you need our chair to repeat the instruction? Thank you. We're good, Ralph.
Okay, so I cannot hear the translator, Santiago, so.
Correct.
Okay. Well, I'll next turn to the roll. Board Member Broad,
Here?
Board Member Flores, Board Member Hall, Santiago, I'm not hearing anything. Is Board Member Hall?
He's not on
Here.
the line. I'll be reaching out to him while you continue roll.
And we saw Cynthia say present, but we didn't hear her. So I'm a little.
Present.
There you go.
Okay,
Present.
Good. Thank you.
Thank
you.
for pointing that out. Okay. So Santiago, you're going to reach out to Board Member Hall then?
Yes, doing that now.
Let's give that a couple minutes. And while you're doing that, I'll point out that also present from our staff for today's meeting, our Executive Secretary, Mr. Santiago Avila Gomez, and who everyone has heard is on the screen periodically. So why don't we pause for a minute?
Todd's on here too.
And Chief Counsel Todd Ratchin is sitting is joined us here in this room. So I guess we'll pause for a moment and give Santiago a chance to contact Member Hall.
Member Hall's working on his technical difficulties at the moment. He'll be joining shortly.
Okay.
Board Member Hall has now joined.
I'm sorry. Oh, there you go. Good morning. I'm calling the roll. Board Member Hall. You're
He's
on mute, I
connecting to
think.
audio at the moment.
Okay.
Okay, I think I got it now.
We got you.
Yes. Okay, perfect. Thank you.
Welcome, and you're present.
Hey, yes,
Okay.
present.
Okay, so we'll move on. Great. We are living in rapidly changing times, and the board is committed to taking steps necessary to protect the health and safety of both our staff and members of the public. Thus, in accordance with Executive Order N2920, today's meeting is being held via video conference with an option for members of the public to dial in. We will first have the business portion of the meeting, which we anticipate to be roughly 45 minutes. We will then recess for approximately 10 minutes and then reconvene to discuss the regulation subcommittee reports. After the close of the regulation subcommittee discussion, which will include the opportunity for public comment on the regulation reports, we will open the meeting up for public comment on any other portion of the meeting. Members of the public who have contacted the board either by email or phone and asked to be placed in the public comment queue will be called on in the order received. If you did not previously contact the board and wish to make a public comment at the end of the meeting, you may do so in one of several ways. You can make a request in the Zoom chat function or raise hand, or you can email Santiago Avila Gomez to be placed in the queue for public comment. Please note that we ask that you use the chat feature only to indicate you wish to make a comment. Substantive comments in the chat will not be made part of the public record. We ask that you also provide your name and organization, if applicable. This information will become part of the official record of today's proceedings. If you wish to speak more than once, please alert the staff and have your name placed back in the queue if you are able. If you have technical difficulties when you are called up, please reach out to us via the Zoom chat function or email, and we will come back to you. We have limited capabilities for managing participation during the meeting and during the public comment periods. So we're asking everyone who is not speaking to place their phones or Zoom on mute and wait to unmute until you are called upon to speak. You can also see these instructions on our agenda, which is posted at alrb.ca.gov, which is located on the ALRB homepage under News and Information. So with that, I would like to move on to the first item of business in the agenda, which is approval of the minutes. So the first item is approval of the public meeting minutes from August 10th, 2021. May I have a motion to approve the minutes?
I'll move to approve the minutes.
Okay. Is there a second?
Second.
There's a second. So let's take the roll. I'll just call the roll, I guess, in alphabetical order. Member Braun.
Aye.
Member Flores.
Aye.
Member Hall.
Aye.
And Member Lightstone. Aye. So the minutes of the August 10th meeting are approved. The next item under approval of minutes is a revision of minutes. There is a correction to the minutes of the board's April 13th, 2021 minutes. The minutes incorrectly attribute a statement to the general counsel that, quote, the ALRB has issued some worker visas in the past. A stakeholder reading those minutes questioned the ALRB's authority to issue visas. The ALRB has no such authority, and the general counsel did not state that the ALRB issues visas. The corrected minutes will read as follows, quote, The General Counsel Montgomery commented that she had signed certifications in connection with some visa applications in the past, end quote. May I have a motion to amend the minutes of the April 13th meeting as indicated?
So moved.
Okay.
Second.
Second from Member Flores. Okay, so let's take a vote. Member Broad,
Aye.
Member Flores,
Aye.
Member Hall,
Aye.
and Member Lightstone, aye. So the motion is approved. Okay, the next item of approval is the regional director minutes from the last regional directors meeting. May I have a motion to approve those minutes?
So moved.
So
Okay.
moved. Second.
Second from Member Hall. Let's take a vote. Member Broad,
Aye.
Flores, aye. Hall,
Aye.
and Lightstone, aye. Okay. We'll now move on to the next item, which is the chair's report. I am presently acting chair while the ALRB's regular chair, Victoria Hasid, is on parental leave, and I am very pleased to be able to announce that Victoria now has a beautiful daughter, Olivia, and that both mother and daughter are thriving. During the first part of the meeting, the board will receive reports from some of the staff leadership. While these reports touch on activity highlights, we should keep in mind that the ALRB staff is working hard every day in offices around the state to protect the rights of farm workers and to faithfully enforce the law. They have been doing this throughout the pandemic while following the state safety guidelines. Later in the agenda, we will be discussing potential regulation changes. This is a pre-rulemaking process designed to help produce the best possible regulations, and we're looking forward to that discussion. And that's the chair's report. I will now turn to the next agenda item, which is the executive officer's report.
Thank you, Chair Lightstone, members of the board. Reporting on activity that's occurred since the last public board meeting on August 10th. There's been no election activity. There's been one complaint filed and one make-whole specification. With respect to the complaint, Guest Cattle Company, LLC, case number 2020 CE 008 VIS involving livestock in Tulare County was filed. The make-whole specification is Rincon Pacific, LLC, case number 2014 CE 044 SAL in connection with 40 ALRB number 4. The General Counsel has settled 3 matters. Mark Benton solely. The parties entered into informal unilateral settlement agreement on October 5th. Sun Pacific Farming Cooperative. The parties entered into a informal bilateral settlement agreement on August 13th. And Braden Farms, where the parties entered into an informal bilateral settlement agreement on August 6th. 4 complaints were withdrawn. One this morning, Dominguez Farms LLC and Man Packing Company. The second, Eat Sweet Farms LLC on September 23rd. The third, San Miguel Produce on September 20th. And the fourth, Your Gut Packing Company on August 23rd. Since the date of our last public meeting, we have not had a virtual in-person hearing and no administrative law judge decisions have issued. There have been no board decisions and there's been one administrative order in the matter of Lily's Green Garden Inc. And that's ALRB Admin Order 2021-07 in order to show cause. My General Counsel's request for subpoena enforcement should not be granted. That matter is pending. This report, as well as other reports, are available on the ALRB website and will be updated as necessary. I'm now available to answer any questions if you have any. Thank you.
Does anyone have any questions? Okay, thank you, Santiago. The next item is item 5 on the agenda, the litigation report. Todd, can you give us a litigation report?
Good morning, thank you. The litigation report is also available on the website. Updates since the last public meeting in August. The Cedar Point litigation was returned to the district court. The parties entered a stipulated judgment, which has now been entered, and that litigation is final. And that's the only update.
Okay. Any questions? Well, hearing none, let's go on to the general counsel's report. Julie?
Good morning. Good morning, everyone. I'll start my report by talking about a few personnel updates at the General Counsel's office or General Counsel program. First of all, since our last board meeting, we hired 2 attorneys in Oxnard, and they've started at our Oxnard sub-regional office. And we've also hired 1 attorney in Salinas. We currently have vacant positions that we are recruiting for a Salinas field examiner, staff services attorney, and another attorney, an attorney in our Santa Rosa office, a legal secretary in our Oxnard office, an attorney in our Visalia office, and we are also going to be shortly posting a regional director position in Visalia, as our regional director, Chris Schneider, will be moving on to another phase of his life at the end of this year. And we wish him all the best and thank Chris for all his service. And so that position will be posted soon. And we're also recruiting for a staff services analyst in our Sacramento office. So please help us spread the word. If you know anyone, please encourage them to apply, and they can look at our website for more information, or the CalHR website. I'm also going to give you a summary of some settlements that we have reached during the past couple of months. One involves 5 raisin grape harvesters in Fresno County who filed charges alleging that Mark Benton Foley, through his farm labor contractor, terminated them after they collectively asked for a penny piece rate raise and then denied them employment in the subsequent season. The General Counsel program filed a complaint, and the company settled with the ALRB prior to hearing for $17,000 in back pay to the workers, offers of reinstatement, and the full standard non-economic remedies of notice, posting, and mailing. We also settled a case in Tulare County for a grape harvester of a charge filed against Sun Pacific Farming. And we also had filed a complaint in that matter. And in that case, the worker alleged that he was not being rehired because he and his crew refused to enter unsafe, muddy, wet conditions in their field. And we settled that case for $12,000 in back pay to the worker, as well as an offer of reinstatement and our standard noticing, posting, and mailing remedies. We settled a case in Santa Barbara County for 14 celery harvest workers who filed a charge alleging that Beta Farms fired them because they complained about how they were told to harvest celery and its potential impact on their wheat. The company entered into a pre-complaint settlement with the ALRB for back pay for the 14 workers of $23,145, as well as offers of reinstatement and the standard notice, posting, and mailing remedies. The Mixteco Indígena Community Organizing Project, or MICOP, in Ventura County also filed a charge alleging that Mars Farms retaliated and discriminated against agricultural workers when it pressured them to work faster, change their assignments, threatened them with job loss, and mistreated them because they spoke about working without pay and had complained to Cal OSHA regarding lack of drinking water in the fields. And the ALRB did enter into a pre-complaint settlement with that company, and that included the standard remedies of noticing and posting and supervisor training for all of Mars Farms Inc. Supervisor personnel about the agricultural labor relations. And finally, a farm worker in Santa Barbara County filed a charge alleging that Betaravia Farms terminated his employment because he complained about working conditions and the way the company had treated workers during the COVID-19 pandemic. And the ALRB entered into a settlement, pre-complaint settlement with the company for back pay of $3,500 to the worker, as well as posting, noticing, and mailing remedies. So those are our settlements that we have achieved since the last board meeting. We have also been hard at work conducting outreach to, to our stakeholders and farm workers throughout the state. We have attended a total of 19 in-person events, and we've distributed information about workers' rights during the COVID-19 pandemic and specific rights they have, and targeted at farm workers that we've developed. We distributed approximately 2,500 of those cards at these events. We've also, and these events include farm worker caravans that we participated in with the Labor Commissioner's Office, food distributions, Mexican Consulate Labor Rights Week events, door-to-door canvassing in various communities where there's farm worker housing, and a lot of other events. We've also distributed our cards with the COVID-19 rights information to approximately 3,200, or we've distributed approximately 3,200 of those cards to community-based organizations, including farm worker resource centers, medical clinics, and legal services organizations. We've held 2 Spanish language radio and television interviews, 7 Facebook Live events on social media, also in conjunction with the Mexican Consulate during Labor Rights Week, and with Cal OSHA, a couple of different presentations together with Cal OSHA. And we've conducted 5 training presentations for worker groups and employers and service providers. And we've trained a total of 83 people in English and Spanish in different parts of the state, and including the Mecca Farm Worker Resource Service Center, and a group of essential workers in Riverside County, and for a couple of nonprofit organizations in Ventura and Santa Barbara counties. So that concludes my report. If there are any questions, I'm happy to answer them.
Thank you, Julie. We're having some technical difficulties with the mute function in the SAC room. I will assist to get them back online here.
So Santiago,
Excellent.
am I unmuted?
No, yes, you are now unmuted. You can proceed.
Okay, thank you. Well, thank you very much, Julie. That was a good report. We appreciate it. Do my colleagues have any questions for Julie? No? Okay. Well, then let's move on to the Division of Administrative Services report. Brian, you're on.
Good morning, everyone. I just have a few brief updates from the Administrative Services Division. We are currently in the midst of beginning the governor's budget development that will be released on January 10th. And as part of that development process, we've gone ahead and begun working and completing budget letters associated with retirement rate adjustments, as well as all of the collectively bargained employee comp increases. So we've done those calculations and are awaiting finance approval of those budget adjustments. In addition, since the last board meeting, Department of Finance did also release a budget letter to all departments notifying them that the OE&E operating expense and equipment reduction of 5%, which had been proposed as part of last fiscal year's budget, is actually going to go into effect starting this fiscal year. So that impact to ALRB will be a $204,000 permanent reduction on operating expense and equipment. So though it was not included in the budget that actually was adopted as part of the Budget Act, there was language that allowed them to move forward with those reductions. So that's an update from our last board meeting. In addition, on the HR front, we are busy working on the open enrollment process, which closes this Friday. As a reminder, this is an opportunity for all ALRB staff to review their benefit plans and make any changes that they would like to have incorporated that would go into effect in January 1st, 2022. So if you have any questions, please feel free to reach out to HR to get that paperwork processed timely. And then lastly, on the business services front, we've been working very closely with the Department of General Services and several facility updates, one of which includes a relocation of the Oxnard office. We've identified a new office suite so that we can have our own designated office building in Oxnard and no longer share it with an existing state agency. We are on track this is a project that's being funded out of an architectural revolving fund that was set aside several years ago for this relocation purpose. And we're working closely with DGS on finalizing the lease agreements and timeframes for the actual move itself, which appears that it'll be in early 2022. In addition to that, we have two other remodels that are going on. One project is associated with the Salinas office, which would be a remodel of that office, including additional furniture and modular furniture replacement. And we're also working on a project in the Visalia office to do some reconfigurations of that office space as well to meet kind of our changing business needs in both of those program areas. And with that, those are the updates I have for the Administrative Services Division, and I'm happy to answer any questions anybody may have.
Thank you, Brian. I'm in the process of unmuting the board members in the large conference room.
Are we unmuted now?
You are.
Okay, thank you, Brian. Do my colleagues have any questions for Brian? Okay. Okay, well, thank you, Brian. With that, let's move on to the next report, which is on legislation, and that goes to Todd.
Yeah, thank you. And the legislation report is also available on the website on the board's meeting page. Since the last public meeting, Assembly Bill 616 was approved by the Senate and concurred in by the Assembly and presented to the governor. The governor vetoed the bill on September 22nd, and that the Assembly Bill 616 would have added a representation ballot card election procedure to the act as an alternative to the secret ballot election procedures, and would have added a appellate bonding requirement as well. So that is the legislative update.
Okay. Thank you. Thank you. Member Flores, can you hear us? Okay, good. Okay, thank you for the legislation report. That concludes the first section of today's meeting. We're going to take a short break, 10 minutes, and then we're going to convene on the next agenda item, which is the Regulation Subcommittee report. And so let's take that 10-minute break and we'll get on to the next step. So thank you, everybody.
Chair Lightstone, I'm stopping the share and unmuting you at this time. You're both unmuted and your video is on.
So you can hear us, everybody?
Yes.
Yeah? Okay.
All right.
Okay, thank you. Welcome back, everyone. We will now take up item 9 on the agenda, the reports from the Regulations Subcommittee. In a moment, I'm going to hand off presentation of the reports to the subcommittee co-chair, Member Broad, and Chief Board Counsel Ratchin. After the presentation of the reports, we'll get comments and questions from the board and public comments. In addition to commenting, the board will have the following options with respect to each report: approving the report, rejecting the report, modifying the proposed regulatory language in the report, or directing the subcommittee to review the comments of the public and the board and to submit a revised report for the board's future consideration. Once all of the reports are approved, they will be submitted for proposed rulemaking as a package following the procedures of the Administrative Procedure Act. The public will then have an additional opportunity to comment. The board may further revise proposed regulations based on the comments during the formal rulemaking process. Again, as a reminder, this is a pre-rulemaking comment period. Okay, so I will now, Member Broad and Counsel Ratchin will now present the 6 subcommittee reports. And after each report, the board and the public will have an opportunity to comment.
Okay, good morning, everyone. So just to reiterate what we've done so far, over the course of the last approximately 1 year, we have asked for and received comment and inquiry from members of the public. And members of the public in this instance include our own staff, the general counsel's office, the administrative law judges. And we had a public workshop as well. And we asked for, comment at a succession of public meetings. And we got some comment from stakeholders. I want to reiterate what Ralph just said, which is that today, if we move forward with these proposals, some of them, all of them, as they are, as they might be modified, we would then begin the formal rulemaking process, which would mean in accordance with the Administrative Procedures Act, we would promulgate formal regulations with a statement of reasons and all the things that are required, and take public testimony on any proposals that we have. Ultimately, if we approve proposals, they would be submitted to the Office of Administrative Law, and upon their approval, the regulations would go into effect. During that period, we can accept comment and make modifications of the proposed regulations, which triggers additional public comment time. But so nothing is cast in stone at this point, nor would it be cast in stone at the point we even formally promulgate the regulations. So there's a lot of time for the public to weigh in on these regulations. So I don't want anyone in the public to feel that if they haven't weighed in on these proposals now, and they shouldn't feel as though they've missed the opportunity to have public comment in the future or to affect, make suggestions for modifications or changes. With that, let me just give you a broad review of what we've done here. These are these regulations, basically you can call them, or put them into two pots. Purely technical regulations that do not change the substantive meaning of the regulations that we have, that are technical and non-substantive. And then there are regulations that you would call substantive. A number of these regulations are that I would call in the area of non-substantive, although they do require people to change their practices, are such things as requiring more electronic filing, removing what you might call references to antiquated technology like the telegraph and signal flags or whatever we have in there that's really old. Sorry, we don't have signal flags, but we do have telegraphs. And to try to sort of, make our regulations fit with the emerging, I wouldn't say emerging even, emerged existing technology. And then we have substantive changes which do affect the substantive rights of the parties or are process changes that are significant enough that I guess you might want to call them substantive. The 6 categories of these reports are divided by subject matter, generally speaking. So some of them are probably more likely to be technical. For example, the very first one, which is completely technical. And some of them may have a mix. So what we're going to do here, what we're going to ask you to do is, first, in a second, I'm going to turn this over to Todd, who's going to give a sort of a broad overview of the major changes that we're suggesting. It's not exhaustive, but the major changes that we're suggesting of a substantive nature in the regulations. Then when we're done with that, we're going to go through these report by report, all 6 reports, throw it open for comments, obviously by board members, then public comment. Then we'll go back to the board for it to make a determination whether to approve that report or not to approve that report. If they approve if we, I guess, approve a particular report, then the subcommittee would then go back with the staff and turn that into a regulation. If we want to hold off on something or revise something or give it some more time, the board can say, well, here are some comments. We've heard comments from the public. We have some comments. Please take that report back, work on it, and present it at a subsequent meeting. Our intention, however, is to move forward with the package as one package. So in a sense, if we approve one of these and another we decide that needs more work because there's public comment which demands more work, or we feel demands more work, we're just going to hold the one we've approved in abeyance, and when we're done with everything and we feel like we have an approved package of all 6 of these, then we will move forward in unison as one regulatory package that will be formally promulgated and start to move through the process, so that when we get to the formal process part of this, we're in one timeline. We're not going to be in like 6 separate timelines. Okay, so I hope that's clear to everybody. The one big substantive area that's been in kind of the news or whatever is that we are not going to address, with one minor exception, we're not going to address the consequences of the United States Supreme Court's decision in Cedar Point. We're going to leave that for the future because it raises a number of complicated issues about what, if anything, to do next, and whether statutory changes would be required in order to authorize what we might think was the appropriate thing to do next. So that's going to be dealt with separately in the future. With that, I'm going to turn to our Chief Counsel, Todd Ratchin, who's going to give this broad overview of the proposals.
Thank you, Barry. And so at the April public meeting, the board approved various concepts that had been proposed by the subcommittee. The subcommittee went back to the drawing table and put those concepts into writing, which we now have in front of us. We will take these all, the reports that are available on the website one by one. There will be opportunities to comment on each, but just to give an overview of some of the more substantive changes that are being proposed in no particular order. As Barry referenced, the filing and service amendments to our regulations to require electronic filing by represented parties while allowing unrepresented parties to continue to file through hard copies or other means, while also making available the e-filing option to them. It's consistent with other labor relations entities and California courts. Mandatory mediation and conciliation, a regulation to govern the supplemental MMC process that is created by Labor Code Section 1164.10, which became effective in 2019. There are currently no MMC cases on the board's docket, but it's about time to have a procedure to govern those types of proceedings when one comes to us. In the cannabis arena, applicants for a cultivation license with 20 or more employees are required to enter into labor peace agreements with a labor organization. You have a proposed regulation to govern some of the interaction between that obligation and our act, and when issues arising under that obligation or alleged violations of a labor peace agreement may implicate the protections of our act. In representation proceedings and elections, we have a proposal to codify a blocking policy and also to govern some of the timeframes and procedures for the impoundment of ballots in a secret ballot election. And also in this area, there's a proposed update to the employee list an employer is required to produce following the filing of a representation petition, which would add employee telephone numbers and email addresses to the contact information required to be provided on those lists. And also, which Barry alluded to, a proposal to, with the notice of intent to organize regulation, a proposal to remove the requirement of a prior notice of intent to take access being on file before a notice of intent to organize may be filed. Then in the unfair labor practice charge arena, there are proposals that would allow a charging party to remain anonymous during a charge investigation, but which would still require the charging party's identity to be disclosed if a complaint ultimately issues. A requirement that a complaint on an unfair labor practice charge must issue within 12 months or else be deemed dismissed in an effort to improve case processing efficiencies. And then with post-complaint procedures, also in an effort to improve case processing efficiencies, a case management conference requirement where the parties could, modeled after CMC requirements and civil actions, an opportunity for the parties to discuss and identify issues and hopefully resolve issues or discovery plans on the front end to expedite the overall process pre-hearing. And so I think, with that overview, if we want to start jumping into the reports themselves.
Okay, so the first report we're going to consider is the report regarding gendered language changes. And we're starting with this one because it's the simplest and easiest to understand. The idea here is that our regulations throughout have references to basically him or her. And in an effort to change the regulations so that they don't offend or create issues for people who do not believe in binary views of gender, we're basically going to strike those and replace them with the title of the person that it's referring to. And these are basically throughout our regulations and would not be a substantive change to the regulations. So that's that. That's it. So we would throw that open to the board, I guess, for.
Yeah, we're starting with one of the simpler ones, as Barry said. So let's just start with that one. On the gender change report, does the board have any questions or comments? Let's start with that. Member Flores.
Oh, thank you. Just wanted to note, well, first and foremost, thank the subcommittee for all of your work. It's a tremendous effort and a very heavy lift. So thank you, Board Member Broad and Lightstone. On this particular report, just want to commend the board for really moving forward and demonstrating our commitment to inclusivity. I think it's the appropriate step to take. That's it. In favor of this report.
Yeah, I too, Mr. Chair, want to thank both of you, you and Women Broad, for your hard work as well. I know it's been long overdue. And I'm sure if the chair, Victoria, was present, she'd be saying the same thing. And so again, thank you so much for your hard work and for all the staff that has spent countless hours working on this as well. So thank you. I'm in support.
Okay. Well, so now I think we'll open it up, Santiago, to is there anyone in the public who wishes to comment on this issue?
There are a few individuals that have expressed an interest in public comment. However, I don't know if their comments relate to this particular topic. Mr. Howard Sagasser, you're first in the queue. If you have a comment to make on this topic, please do so at this time. Okay, we'll go to the next person. Mr. Michael Marsh, if you have something to comment on this topic, please do so at this time.
No, my comments for a later matter.
Thank you. And finally, Mr. Brian Little, if you have a topic, or I'm sorry, a comment on this topic, please do so at this time.
I prepared a written, I had prepared a verbal comment that I wanted to use as a comment on the entire regulatory package. If I could have some time when we reach the end of the discussion here, I think it would be more appropriate.
Thank you.
So is there anyone else, Santiago?
There is no one else. There are two additional speakers, but they have indicated their interest to comment on the labor peace agreements.
Okay. Well, then let's go back to the board then. I think what would be in order, the board, if the board wishes to approve the subcommittee going forward to formal rulemaking with the gender language changes, then we could, if there's a motion on that, we could probably take a vote. What will happen though is, Member Broad said, is it's not going to go into the formal rulemaking separately. We're going to wait. We would put this, on the shelf waiting for the all of the others to come along, and then we would move them as a package. So I don't know, is there a,
Yeah,
I'll move to approve it.
I'll
Second.
second.
okay. So I'll call the roll. The motion is to approve this subcommittee report to move forward. Member Broad,
Aye.
Flores,
Aye.
Hall,
Aye.
Lightstone, aye. Okay, we've dispensed with one.
All right.
Okay,
So the next package is the package dealing with the MMC, or mandatory mediation and conciliation language. And so that, as Todd mentioned, that essentially creates regulations for the first time to govern supplementary MMC, which was created by legislation that went into effect in 2019. So that's it.
okay,
So
We're just.
okay. So would any board members wish to comment on the MMC report? Well, hearing none, I guess we'll go to the public. Santiago, is anyone in the public queue interested in commenting on the MMC report?
Of the individuals that have signed up and have not indicated what they wish to comment on, Mr. Howard Sagasser, if you have a comment on this topic, please unmute yourself and proceed. Thank you. Okay, hearing no one and everyone else having indicated what they wish to comment on, you are free to move forward, Chair.
Okay, so I guess we're back to entertaining motions.
I'll move it.
Second.
Okay, let's call the roll on approving this subcommittee report to move forward. Member Broad,
aye.
Member Flores,
Aye.
Member Hall,
Aye.
Member Lightstone, aye. Okay, we've dispensed with subcommittee report number 2.
All right. Report number 3 is cannabis labor peace agreements. As Todd mentioned, the government code,
Business professional.
Business and Professions Code provisions regulate the cannabis industry. And in those, there is a reference to a requirement in that law that that employers that must have above 20 employees must have a labor peace agreement as a condition to obtaining licensure. These regulations that we are proposing, actually it's really one regulation that we are proposing, makes that that statutory requirement in the Business and Professions Code enforceable through our unfair labor practice system as well. So that's the general purpose of the regulation.
Okay, so let's, on that one, Todd, unless you have something to add.
No, I think it's time to take.
Okay, so let's hear comments from the board about the cannabis report. Do you have any comments?
Have none.
Okay, So Santiago, let's go to the board doesn't have any comments at this time. So can you go to the public? I think you indicated someone wanted, there were some folks who wanted to talk about this.
Correct. And that would be Jassy. I'm sorry if I mispronounced your name. Jassy Grewal. If you are on the line, please unmute yourself and provide your public comment.
Hello, my name is Amber Bauer. I'll be making public comment for Jazzy, who's unavailable at the moment. My name is Amber Bauer. I'm the Executive Director of UFCW, United Food and Commercial Workers, Western States Council, representing workers in the cannabis industry. Our comment is that we would support this regulation, but ask that the employer be required to notify any other unions that have assigned LPA when a union is executing an LPA. So this would ensure that other unions are aware of the LPA's execution when an employer has signed more than one LPA.
Can I ask a clarifying question?
Yeah.
Would that be a notice that the employer provides after it executes an LPA with one labor organization, or something that would be triggered by a request by another labor organization?
I think what we're asking,
Go
yeah,
ahead.
after one labor organization. So if there are other unions that have signed LPAs with the employer, that they're notified when one is executed.
Okay, so let me just, can I ask?
Of course. Let's get clarity on what was.
So I just want to make sure. So an employer signs an LPA with the union. At the very first time, nothing happens because there is no other union that has an LPA. Then another union comes forward and requests to sign an LPA. An LPA is signed. I have a couple questions. First, is the obligation of the employer to notify, in that case, I guess, both unions? Is it triggered by the subsequent union's request to enter into an LPA, or upon the actual execution of it, in your view?
We're asking on the execution.
Okay.
That any other union that has a signed LPA, that they're notified that an LPA has been executed.
All right, so then with each subsequent one that is executed, the obligation on the employer would be to send out notice that there is an LPA to all the prior unions with which an LPA has been signed. And I guess the new union said, talking about the previous one, since.
That's right.
Right, okay. Now, one last question. Does your request include some requirement? And I don't even know if this is even appropriate, but are you intending it to include some requirement that the actual LPA of one union be made available to another union?
In the text of it?
The actual text of it.
No, we're not asking for the LPA signed with another union, just the fact that it has been signed.
Okay. All right. Are you planning to submit this request in writing to us?
Yes, we can.
Okay. I think it would be very helpful to us if you did, and even if you don't have to do this, but if you had language that you wanted to suggest that we adopt for this, that would be helpful to us.
Absolutely. Yep, that makes sense. Will do.
Okay, thank you.
Okay. Does any board member wish to comment? Because we'll go to the next public comment.
Yeah.
Okay, Santiago, let's, I think there's someone else that in the public queue, maybe?
Actually, it was Miss Amber Bauer that was going to comment for Jazzy. The only other person that has expressed an interest is Mr. Howard Sagasser, and I don't know if he has a comment on this topic. I invite you, Mr. Sagasser, if you are with us, to unmute and provide a comment if you wish on this topic. Doesn't appear he has joined us, so you may move ahead, Chair Lightstone.
Well, it seems like based on the conversation that we just had, that this one would require further work because we've invited the commenters to submit language. So I guess I would.
Yeah, I think what I would suggest to the board is that on this proposal that the board allow the subcommittee to receive testimony or receive the comments that the United Food and Commercial Workers intend to make. And we do have to set out some kind of a date and all that stuff when comments are due, but and that we bring this proposal, this package back to the board at the next board meeting with a recommendation and language. I don't know, does that need a motion?
Yep, probably should just
Okay,
do a motion.
well then I'll move that.
So the
I'll
motion
second.
is, just for clarification, the motion is to send the report back to the subcommittee for further consideration pending comments, remarks from UFCW, correct?
Right,
Yes.
Okay, and incorporating those and then bringing it back to the December meeting.
correct.
Okay, wonderful. Second, sorry, are we voting now? Aye.
Yes. Well, we have a motion. Do we have a second?
Second.
Second.
Okay. Second from Member Flores. I'll call the roll. Member Broad.
Aye.
Member Flores.
Aye.
Member Hall.
Aye.
Member Lightstone. Aye. Okay.
All right. Okay, so far so good. All right, the next package is the filing and service related regulation package. This is a fairly long package, I believe around 31 or 32 pages, and it covers a lot. I think most of which is probably not, is pretty non-substantive and is technical in nature. But there also may be some things in it that parties wish to comment on. So I'm done. I think that's it. And just, in terms of.
Yeah, the real meat of this one is the electronic filing requirement, and then, many of the other proposed changes are to conform the other regulations to that requirement, to remove the requirements of multiple copies of documents being filed with the board, which we won't need in e-filing. So that's really, but the bulk of it is the e-filing requirement.
Which applies to the mandate applies to represented parties, and for non-represented parties, they have the option.
Correct.
Okay. Well, are there any comments from board members about this proposal?
Long overdue.
Member Hall?
I'm good to go.
Okay. Okay, so Santiago, do we have anyone in the queue that would like to speak to this proposal, this report?
And the one commenter that has not specifically named an interest, Mr. Howard Sagasser, if you wish to comment on this topic, please unmute and provide your comment at this time. Okay, appears that there is no further public comment.
So I guess I would entertain a motion to have this subcommittee report move forward.
I'll move the item.
Okay, Member Hall moves the item. Member Flores seconds. I'll call the roll. Member Broad,
Aye.
Member Flores,
Aye.
Member Hall,
Aye.
and Member Lightstone, aye. Okay.
Okay, so the next package is, deals with unfair labor practice procedures and other general procedural changes to our regulations.
Okay. Todd, do you want to underscore any particular parts of this, or should we just?
I don't think beyond some of the highlights, if you will, from the my earlier statements, that I think that we're ready to take comment.
Okay. Shall we, let's start with the board. Member Flores or Hall, do you have anything you want to say about this one at this time?
Yeah, I did.
Okay.
So I appreciate the comments that we received from Administrative Law Judge McCarrick and Craycraft, specifically their first comment or their comment on proposed changes to Regulation 2022-0C. And to that end, I think it would be worthwhile for the subcommittee to more clearly communicate or clarify the establishment of a limitations period from charge to complaint, and the fact that it need not create a laches defense, or just explore kind of that tension. So that's something that I wanted to bring to the subcommittee.
Yeah, if I could respond to that.
Sure.
I just want to make it clear that from, I think, the subcommittee's point of view, that establishing an actual fixed date by which time a complaint needs to be filed is not establishing a laches defense. It's sort of the opposite of a laches defense, in the sense that a laches defense is an equitable defense that allows which a party raises, and there is no fixed standard for when a claim has become so attenuated, it's so long that it's no longer equitable to the parties. And our concern was that it then requires the board to act if we were to have laches, which we don't currently now, and there's a question whether we even have the authority to establish a laches defense. But it's one of those, you know it when you see it things. So it would be like, well, it's 3 years too long, it's 4 years too long. It would be case by case. We would have no actual standard, and it wouldn't really be very beneficial in terms of creating regularity for the parties. So our general view is that and recommendation is that there not be a defense of laches, but that there be a fixed deadline with maybe some additional extensions, as we have. An extension is what we have, but with an extension, or maybe more than one, or under different circumstances, or whatever the board ultimately decides, to allow the general counsel not to be prejudiced by dilatory conduct on behalf of a respondent who's trying to run out the clock by not cooperating and not producing evidence and not responding appropriately to requests for information or subpoenas or whatever is going on. So anyway, that's the general view of what we're doing vis-a-vis the defense of latches.
Thank you.
I think I think I might add, something that I think that as we talked about this issue, I believe there is something of a consensus that it's important to move our cases along in a timely manner because the general counsel is the moving party in these cases, and evidence tends to dissipate over time, so that one doesn't want to have many years of long delays in process. A charge is an allegation, and the case really begins once the investigation is complete and the general counsel either issues a complaint or determines the charge is not meritorious of issuing a complaint. So I think there's something of a consensus in all of us that unlike civil court, administrative cases, when the government is enforcing the law in this way, have to move along. The question then becomes, how fast, what exceptions, what can we do to expedite things? And what we don't want to do, of course, is, as Member Broad said, is invite respondents to run out the clock, and we don't want to get rid of meritorious charges. And I do note that the common law laches cases correctly say that the person who has suffered an alleged unfair labor practice shouldn't be punished because the government is slow in investigating and prosecuting their case. So, I think we're aware of all that. So I think the goal here is to figure out the right way to address this concern, to move the cases along and keep going, but also, not allow to move them along without, causing harm to meritorious cases. So.
Absolutely, and I think we're all in agreement with that. And I can see in the report that the general sentiment and spirit of the recommendations is to more effectively and efficiently resolve matters before the board. So I appreciate your comments. Thank you.
So I guess we'll open it up. Go ahead.
Did we reference the public comments that were received?
Well, we didn't. I think somebody mentioned it, but we have received two public, at least one public comment on this, right?
On this topic.
Well, we have it's on our website. We have a written one from a couple of the administrative law judges who. And if you're interested in this subject, everyone should take a look at those comments.
Yeah, the written comments received by the board are available on the board's meeting page on the website.
Right. So Santiago, with that, I assume that we have some people that want to talk about this one.
That's correct. And again, Mr. Howard Sagasur, if you are on the line and wish to comment on this topic, please unmute yourself and provide your public comment now. Okay, moving ahead to Mr. Michael Marsh. You may unmute and provide your public comment now.
I thank you for letting me speak. My name is Michael Marsh, and I'm an attorney with Agricultural Labor Relations Board in Salinas, California. I've been with the agency for about 6.5 years, and prior to this, I was an attorney with California Rural Legal Assistance for about 10 years. I agree that we need to do something to ensure that these cases get investigated promptly and efficiently, but I don't believe that this is the correct proposal to achieve that goal. I have always promptly and quickly attempted to investigate the cases that have been assigned to me, and there have been many cases where I've been able to complete an investigation and prepare an agenda summarizing my results, my findings, within 3 or 4 months. But there's also been a number of cases where I have had to take 18 months, 20 months, 21 months to do the same thing. And there's a variety of reasons for this. Sometimes it's because we have trouble reaching farm worker witnesses who have crucial information to the investigation. This can happen for a variety of reasons. You know, workers may go to Mexico and it's difficult to find them, let alone communicate with them there. Or we'll have celery workers who might pass from Oxnard to Salinas to the Yuma area. We might have berry workers that go from Oxnard to Salinas to Oregon or Washington. Workers migrate, and many workers don't always have the same phone number. Their calling card expires. They don't have any minutes left, or whatever it might be. We spend a great deal of time locating witnesses, and at times even charging party. So that sometimes is a problem. Other times, it's a problem with the employer. I had a case that actually led to a board decision in Smith Packing, where counsel for the company said, well, the season's going to be over in a few weeks, and can't you delay your interviews with our supervisors and our foremen until the season ends? And we routinely get requests to delay our investigation for the convenience of the employer. And when possible, we like to give them the space they need to operate their businesses. And when their requests are reasonable, we grant them. In that particular case, I waited several weeks until the season was over and sent a request to interview the foreman and the supervisors I needed to. And I was sent a response a couple of weeks later saying that the workers, their employees were now in Yuma. And so frustrated that I had waited, I subpoenaed the workers, and I said that I would go to the closest point to the California-Arizona state line, and I would be willing to interview them there. And in this particular case, it was pointed out to me that my subpoena was without any effect or power in the state of Arizona, and they wouldn't be producing the witnesses. So that was a case that I had to wait until the workers, the foremen and the supervisors returned from Yuma in March or April of the following year. And so that's one example. And another example, perhaps less nefarious than that, involved a solo practitioner, a case where the attorney in Santa Maria represented an employer, and she asked for some time, a couple of months, because she was pregnant and was going to have her child promptly. And I said, yeah, well, we can wait a couple of months. And then it turns out that she had some difficulties with the pregnancy. And then she called me and she said she was back at work. And shortly thereafter, her husband passed away. And so, you know, I'm in a situation where I want to be sympathetic. And at the same time, here we have a solo practitioner. And on the occasions when she did have somebody take over some of her cases, that person knew very little about what a case was involving and nothing about our agency whatsoever. And so that happens. We have problems getting the information from employers at time, or working with their counsel at times. So for those reasons, while I laud the attempt to try to get these cases moving quicker, and while I recognize that this particular board has had a few cases that have been land in your lap that have been around too long, I don't think this particular proposal is the right way to address the concerns. And my big worry is that we will end up punishing farm workers and charging party for the delays of our agency. And I think that's inappropriate. That's all. Thank you.
Thank you, Mr. Marsh. I am unmuting Chair Lightstone and waiting.
Thank you. Appreciate that. Well,
Public comment.
does any of the board
There's-
members have any question or comment for the current person, Mr. Marsh? Okay. Is there anyone else in the queue that would like to comment?
There
Santiago?
is
Okay, let's go on to the
Miss-
next one then.
Ms. Veronica
you.
Cervantes. Please feel free to make your public comment now.
Hi there. Thank you for allowing me to speak on this topic. I want to introduce myself. My name is Veronica Cervantes, and I'm a field examiner here with the ALRB. I work out of the Visalia Regional Office, and I have worked in this capacity for approximately 13 years. I want to say that I do recognize the value of having a timeline and setting deadlines to move our cases along. However, this regulation, I feel, fails to recognize the differences between the type of charges that we investigate. No two charges are ever the same. And this proposed regulation assumes that all investigations can and should be completed within the 1 year period. In my experience, in investigating charges, delays during investigations can happen for many reasons, some of which my coworker, Michael, has mentioned. For example, staff often have difficulty in reaching and communicating with the person who has filed the charge after that charge has been filed. We experienced delays in receiving information from the company the charge was filed against, given the amount of information we request in order to complete a thorough investigation. And we often have difficulty locating farm labor contractors and or witnesses who can provide pertinent information to our investigation. So I feel that having a one-size-fits-all rule would harm the farm worker community that we are charged to protect. It would discourage farm workers from seeking our assistance. And although we say it wouldn't force general counsel to dismiss meritorious cases, I do believe the risk is there if we do not complete investigations within our 12-month timeline. I know the proposed regulations would allow for an extension. I believe a 60-day extension, if granted, is too short and may not provide any substantial difference in that investigation. Furthermore, it would limit our ability to cooperate and work with represented and unrepresented employers on information request extensions. And finally, it would remove the flexibility to pause an active investigation in order to explore and pursue settlement negotiations. For these reasons, in my humble opinion, this regulation would have significant negative effects on the protection and assistance we provide the farm worker. Thank you for your time in considering my input.
Thank you. I'm unmuting the
Can you hear
chair's
me?
mic. Yes, we can hear
Okay,
you now.
thank you. Member Braun has a question.
So I don't want to put you on the spot. You don't have to answer if you don't feel comfortable answering. But, we can probably all agree that 4 years from the time a charge is filed to a time a complaint issues is, say, too long. And if we were to put a limit of 4 months, it would be way too short. So there has to be, in our view, a sweet spot, so to speak. So if what you're saying is that the year itself is not particularly unreasonable, but the extension that we're saying is too short, what is an extension period that would be work for you?
This is Michael Marsh again. I'd like to address that if that's okay.
Sure.
I don't believe that there is a time limit that would satisfy me. I agree 4 months is too short, and hopefully we get cases done sooner than 4 years. But I have a philosophical problem with having the charging party and the discriminatees pay the price for the general counsel's slowness in processing a case.
But yeah, I understand that. I do, however, and I'm gonna, in my 40 years as a lawyer, I'm gonna say something that I think is true that happens in litigation, which is the lawyers on both sides sometimes slow a case down for their mutual convenience and not for the convenience of the charging party. I'm going on vacation and I'm going on vacation. And pretty soon, 4 months goes by, and it's a way of controlling workload for both parties. And I'm not sure that that sort of situation, which happens, I think, all the time, throughout the whole legal system. It's not at the ALRB, it's probably at the ALRB and it's at the DA's office, it's in every bit of civil litigation. It's throughout the whole system. It's why public defenders routinely waive their clients' right to a speedy trial, because nobody wants to have the speedy trial, even though that might help their defendant, in truth. But, and so I think the concern I have is that if we do nothing, then that scenario, which is far more common, and I think is damaging to the basic fabric of the type of justice this is supposed to be, which is swift. And because the delay undermines the value of the enforcement, in particular in agriculture. And so I'm a pretty strong supporter of this because I believe it may be inconvenient to the attorneys sometimes. And I personally am happy to entertain proposals that would toll the time limit if the opposing counsel has a health emergency, or tolls the time limit when the parties are engaged in negotiations, for a reasonable period of time. It doesn't take 6 months to negotiate the resolution of an unfair labor practice charge. Either you can figure it out or you can't. And at the same time, when we look at our statistics, we routinely see cases that are taking 2.5 years, 3 years, and it's just too long. And I think we need to do something. I can't speak for my fellow board members, but I really think we need to do something. And I think it is going to create some pressure in the system. And it may mean that the general counsel's office is going to have to move more quickly to subpoena documents and to seek enforcement of a subpoena that is not being complied with. And so that we don't get into a situation where in this system of jurisprudence, it's expected by respondents' counsel that game playing with time is appropriate, is part of the system, because I don't think it should be. And that's where I'm coming from. I don't want to harm farm workers who are filing meritorious complaints, but I do, but what I guess I'm saying is, yeah, this may create pressure on the general counsel's office and pressure, and as a result, pressure on the respondents' counsel. But it, in the long run, will greatly benefit the farm workers who file charges because they're going to get faster justice. That's just my view, and I'm happy to hear your responses or screams of agony or whatever.
Yeah, well, I mean, I would want to address one assumption that I don't believe is true, and I don't think it's attorneys on either side looking for vacation time that delays these cases. I really think it is problems with witnesses, problems with discovery. Investigations take time. And I don't think that's unique to our agency. I know when I first started here 6.5 years ago, there were lots of old cases around, and a lot of them plopped down in my lap. And every new attorney who started, 5, 6, 7 years ago, I had a number of old cases fall in their lap. I actually think that probably right before COVID, we probably had very few cases that were over 2 years old. I think that we were really getting around to clearing the backlog and doing a pretty good job of catching up. And I think that there are efforts that can be done to improve that. I think our general counsel has done a great job at closing a lot of the older cases. I think the CMCs do a good job of encouraging people, and the settlement conferences do a good job of encouraging people to come together at the table and try to get these cases moving and solved and resolved as quickly as possible. But what bothers me is that all of the any incentive there might be to slow these cases down on the part of respondent will only be amplified by this proposal, will only be amplified. And that's what worries me. I think with this isn't something that you see in the NLRB, and to the extent that there is a time limitation in the DFEH, with FEHA, it's not an apples to apples comparison, because if I'm a person who's brought a charge with a FEHA charge with DFEH, and I don't like what DFEH is doing it, well, I ask for a right to sue letter, and I can find myself an attorney and I can go my own way. But here, charging party can't do that. Charging party can't ask for a right to sue letter from the general counsel because we have sole jurisdiction over our act. And the only path to complaint is through the general counsel. So I feel for those reasons, this proposal will unfairly punish farm workers. I think we need to look for other ways to keep cases on track and moving along quickly, and this just isn't the way to do that.
Chair Lightstone, there are 2 additional commenters, but there is first a response to Member Broad's comments and questions. I'd like to call Ms. Francesca Herrera to unmute and provide her feedback.
Thank you. And I think Michael actually covered a great deal of what I was going to say, but I do want to just highlight Judge Craycraft and Judge McCarrick's position or written comment that I think addressed this quite nicely, is that this is a public right. This is not a private right. These workers can't find legal counsel and circumvent delays in the general counsel program. The general counsel program right now is committed to moving quickly. We're creating internal procedures to do that. But in other administrations, I can't say that would happen. If we have another administration, another general counsel program, or a great loss of our staff to other agencies, you could have an inordinate slowdown. And then the brunt of that slowdown falls on the worker, not on respondent, not on the attorneys, but on the worker. And I really think that the importance of the latches discussion in ALJ Craycraft and ALJ McCarrick's written comment was to bring out that the NLRB has recognized that workers should not pay for agency delay. And that is precisely what would happen here if there's a 1-year statute of limitation in the current regulations as drafted. And I do have other comment, but I will save that because this was only in response to Board Member Broad's question. Thank you very much.
I think that's a very good point.
I'm not sure we're open here.
I think that's a very good point that both of you are making. When we examined this recently in a case, I'm not sure the courts of appeal necessarily agree with the NLRB that a defense of latches is not available to employers. It's not as clear as I think you might be suggesting. It's that there is never a defense of latches. And I think we do face a problem if there are cases that take a very long time that a court of appeal will, and an employer raises a defense of latches and says that witnesses have disappeared and things have happened and it's prejudiced them, that they will apply that and we may be stuck with it. And that could be that could be a significant problem also for farm workers. But I do think the basic point you're making is valid. And I certainly like to hear what the other alternatives are that will assure that these cases move along. You both mentioned that, and I think that that's, if there's some other way to do this through regulation or not through regulation, then we should definitely consider it, and I would really appreciate hearing what it is.
Would you like me to continue with the public comment at this time, Chair Lightstone?
Yes.
The next commenter is a Spanish language speaker. And so you will have a translation from the interpreter. We're working out her protocol here, so bear with me. We're going to be. We can hear you. Thank you.
But we can't.
Are you able to hear?
We can't.
The interpreter, Chair Lightstone?
We cannot.
Okay, they cannot. So in the past, we've been able to flip the interpretation. We're having issues with that right now. Therefore,
so everybody else can hear it, the
that's
interpretation
correct.
but us.
You know, I might do a workaround, Santiago, which is I could log in on my computer as a guest and do the interpretation button. Let me try that.
That will work.
Because I have the computer here in the room. So let me join the Zoom. See if I can.
In the meantime, I will introduce the next speaker, Juvenal Solano, who is representing the Mixteco Indígena Community Organizing Project. And I'm admitting you now, Chair Lightstone. You may want to mute your mic on entry if I don't get to it.
Mute your mic.
Over here?
I think so.
Interpreter, can you test the line now?
Me
I
avisan
believe
cuando
they
estén
are
listos.
logging into the English channel at this moment.
I'm muted. Yes, we can. Very good.
Muy bien. Buenos días a todos, todes. Mi nombre es Juvenal Solano. Soy organizador comunitario con la organización comunitaria Proyecto Mixteco Indígena aquí en el condado de Ventura. Y pues he tenido ya muchos años de experiencia trabajando con la comunidad trabajadora del campo. A la misma vez también he sido trabajador del campo por 8 años. Entonces, la propuesta que se está discutiendo hoy sobre limitar a 1 año el tiempo límite para desechar los casos. Pienso que es muy corto, tomando en cuenta todas las barreras que ya comentaron algunos pues compañeros aquí, como por ejemplo que la gente se está moviendo de un lugar a otro, cambia de teléfono o número de teléfono constantemente y también para hacer las investigaciones creo que un año es muy poco. En este trabajo que estoy haciendo como organizador comunitario, he estado envuelto en otros casos que no son precisamente con la ley laboral, pero que son con otra agencia del gobierno. Y ahora mismo estamos en el segundo año de las investigaciones. Entonces, no se trata solamente de las investigaciones que hacemos nosotros como organizaciones comunitarias, pero después de nuestras investigaciones, nosotros decidimos a qué agencia podemos referir a esos casos y entonces lleva tiempo a que la agencia empiece a hacer sus propias investigaciones y pues un año, como he comentado, no es suficiente para poder recolectar toda esa información porque no depende nada más del trabajador o de los representantes de la agencia, sino que también va a depender pues de los representantes de las compañías. Entonces, si ellos aprovecharan, ¿verdad? Este tiempo, por decir, solamente es un año de tiempo límite que se tiene para cerrar el caso, entonces ellos bien pueden usar eso en contra del trabajador y darle largas a los representantes de la ley laboral para obtener toda esa información posible para poder decir que este caso es un caso pues que tiene mérito, ¿verdad? Y continuar. Entonces, un año es peligroso. Entiendo que quisieran hacerlo de buena fe, de hacer que los casos se muevan más rápido, pero también necesitamos pensar cómo piensa la otra parte, en este caso que es la compañía. Entonces ellos pueden usarlo en contra de los derechos de los trabajadores. Entonces, nada más quiero pues comentar eso que por experiencia los casos no se resuelven en un año. Si así fuera, pues sería muy bueno, ¿verdad? Pero difícilmente como está el sistema ahora que tenemos de burocracia, los casos no se resuelven en un año y quería que pues tomáramos mucho en cuenta pues esa situación, ¿verdad? De no estar limitando. Ahora sí que la voz de los trabajadores del campo, no estarlos como presionando de que en un año se va a resolver todo y porque no es así. Entonces, ese sería mi comentario. Muchas gracias.
Thank you. And Chair Lightstone, the mic in the conference room should be active.
Sorry.
Basic.
Wow.
Are we back on?
You are.
Okay. Well, thank you for those comments. Would any board member like to follow up on that?
Yeah, I have one comment. I just want to, I understand the point, but we are talking about just the time to issue a complaint. And there is a hammer that the general counsel has, which is they can issue the complaint. And then they have all the rights of discovery that are available to a party that's issued a complaint. And there is no time limit after that point. So it's not like the whole thing is going to get resolved in 1 year, although that would be great. It's only the question of whether a complaint will issue within 1 year. And while I'm very sympathetic to the comments that are made, and I really would not want this regulation, should it go forward, to have the impact of allowing employers to run out the clock on every charge that's filed through successful dilatory tactics. I have to believe there's a happy median here. And I don't know if maybe 1 year is too short or what we need to do, but I do think that there is something that we can do so that we don't have these cases taking many years to move forward to a complaint, when the likelihood of having with available witness testimony goes down substantially because the workers are long gone from that employer's employment. So, but with that, I would suggest that given the comments that we have, that we send this one, back to the drawing board and consider the comments that we've received and any suggestions that folks might have to make to either fix the regulation we have or suggest some alternative, if there is any alternative, and come back to the board at our next hearing. That would be my motion.
Second.
Chair Lightstone, and sorry to interrupt before you go to your motion, there are 5 additional public comments as well as a response to Member Broad's comments. How would you like me to proceed?
Before, we should also, this topic, has everyone's attention, but we also have the rest of the report in front of us if people wish to comment, I think, on other proposals in this report.
Right.
I'm sorry, I apologize. Yes. I thought we had no further.
Yeah. So let's hear the additional comments, and as Council Ratchin just pointed out, commenters should feel free to comment on other aspects of the report if they have any comments on it. And the other thing I would just add is that if there is, in addition to proposing other versions of the proposal, if there are other concepts that people want to raise on how to expedite these cases, we're very interested in hearing about suggestions to help expedite things. So let's go to Santiago, to the next comment.
Thank you. The first will be in response, Francesca Herrera.
Really brief. You had mentioned that once you have a complaint filed, then you can avail yourself of discovery. Discovery rules under the ALRB are very, very limited, and I just wanted to point that out. It's not like civil discovery. So while there's a 1-year statute of limitations in DFEH to file a complaint, once they file a complaint, they can avail themselves of all the normal discovery methodology, all the interrogatories and requests for production and depositions, and that is not the case here. When we issue a complaint, our investigation is generally complete and we are ready to take the case to hearing. So that it's a different process than what I thought that your comment contemplated. So I just wanted to respond and clarify.
Do you want to say anything? Okay.
But you still have the power to subpoena documents, right? And witnesses.
Are we open? Oh, we're not. Here, let me go ahead. Try again.
So, Francesca, you still have the right to subpoena documents and witnesses.
Yes. We do not do investigative interviews after the filing of the complaint. There is a very limited prospect to do a deposition in very, very limited circumstances that I think I can remember happening one time in the past 8 or 9 years. That a deposition actually took place post-complaint. It just doesn't normally happen. Generally, when we file a complaint, the hearings are set within 3 months. pretty quick, and we're ready to go to hearing. But you are correct.
Okay. Shall we go to the next speaker?
Yes. Jessica Arciniega, please unmute and provide your public comment at this time.
Morning, good afternoon. We're right at the cusp. I currently serve as the regional director for the Salinas region of the ALRB. And prior to that, for the last 9 years, was an attorney in the Oxnard office. So have conducted many investigations, a couple of hearings, many settlement negotiations, and informally resolved matters. I'm speaking today, I guess, from my experience of those 9 years with investigating and litigating cases. And I just, as I'm sitting here listening as well in this role of the regional director, I understand and I wholeheartedly agree with our need to move swiftly to seek justice for those claims. And I also sit here very aware that we are serving and moving in a very unique industry with a very unique workforce. And so as much as we want to capture and impose a bright light, a line, a drop, I don't think that the act, or I should say, I think that the act and its considerations for farm workers and the unique industry that this is, I think that should assist us on being open to the fact that there may not be this bright line. And cases that take 4 years from the filing of the charge to the issuance of a complaint are not the norm. There's many cases that are resolved informally, many investigations that are done and complaints issued under that time. But there's also many factors that our staff and that we attorneys are grappling with. And they've been mentioned, but I'll just mention a couple that I would love you to take into consideration. One of them is that there's still migratory patterns with farm workers. And Michael Marsh talked about workers moving from Oxnard to Salinas to Yuma, which is one of them. But here in Ventura County, where there's the majority of the industry now is in berries, and growers have expanded their operations from not only being in Ventura County, but now being in Santa Barbara County and some being up in Monterey County. There's many opportunities for workers to move to pick strawberries. And all of that moving, we may not really understand how that we don't do that normally throughout the year. And so that requires changing of addresses or physical locations, our shelter, oftentimes in limited spaces. So people may not have, pick up a whole house, a whole bedroom, and be able to move everything to another location. And this relates to when we're seeking pay stubs from workers, when we're seeking other type of documentation, maybe a charge that was filed in one county, and now they have, very limited backpack or whatever they have to move to their next location in Santa Barbara County or into Monterey County, and that paperwork's not with them necessarily. Let alone the fact that if they have a cell phone, oftentimes in our experience, it's more tending to be something that's a prepaid option, which means that once the minutes that they've purchased are used, that phone may be out of service, and they may have to wait until they get their first check at their next location to pay their bills and then have extra money to put more minutes onto that prepaid cellular phone. So that creates a huge gap sometimes for us in our ability to communicate with folks. If they can get that same number on that prepaid phone, then our staff, and we do a great job of continuously calling just in case now they have minutes on that phone, or just in case they gave that phone to a relative or the relative was able to pay for minutes and now that relative can answer it, and maybe they'll trust us enough to let their, relative know who originally filed the charge that we're looking for them and that we want to talk to them. And all of that takes a considerable amount of time. So, workers that move locations as well may not always be as open as we may think to identifying themselves, where they are in this new place, in this new company, in this new town, amongst new coworkers, to continue conversations with our office. These things take time to continuously build trust and build rapport and to be able to contact people. So I wanted to talk about that. Just a little side note on changing addresses. Oftentimes people are renting rooms. There can be a variety of reasons of why workers decide to move before the job ends. They may have a falling out with somebody. They may find that they need more space for a variety of reasons. And so them, changing from one location to another is oftentimes a very strong need and not necessarily contemplating letting the ALRB know where that new address is. Oftentimes our staff, again, we do a lot of various attempts. So we'll go to the last known address and we'll talk to somebody there, and either they'll welcome us or they'll shut the door on us. And then we'll have to try again at a different time. Go on an afternoon after they've gotten off work. Go on Sunday when no one's working and maybe they're gonna leave to go do laundry. Go on a day that we know it's raining because they won't be working today or they'll be home early today. And these are all things that I don't know how much, is shared, but these are things that our staff routinely does consistently to maintain contact and to move our investigations forward. So I wanted to talk about that. And then I just wanted to, let's see, I just wanted to talk a little, again, within, considering the unique aspect of this population, of this industry, just really taking into consideration, it's not necessarily that both sides, if you will, can game. Really in my 9 years here, I haven't purposely slowed down a case, and I don't know of staff that I work with that do that either. We are overwhelmed at times. And I guess what I wanted to say was that, we are not an agency that's looking at a check stub to determine, was this person paid for the boxes they harvested? Was this person paid overtime? These are not simple determinations that can be ascertained from documents. Mostly they can't, because we don't have documents that say, this person, there's not documented PCA, and there's not necessarily documented terminations. And so a lot of our cases and a lot of our investigations are about circumstantial evidence. They're all about, what the motive was. And very, very few times is somebody going to admit that they were motivated to take an adverse action because of somebody's prior PCA. So these investigations are not simple. They're layered, they're complicated. One aspect is ascertaining PCA. There's a lot of elements and layers there. Was it concerted or not? Was it protected if it was concerted? And then we turn to the factors of, was the action adverse or not first? And then was it causally related? So there's a lot of layers here with a lot of these elements, and our investigations, to do a thorough investigation, either to dismiss or to issue a complaint, are very, very intense. And they take a lot of time sometimes, considering everything else that I've mentioned and that my colleagues have mentioned. I just wanted to share that information with you all to take into consideration. Thank you.
Thank you, Jessica. I am asking to unmute the conference room where Chair Lightstone is. Excellent, I can hear you now.
Okay, good. Thank you very much. Does anyone have any comments or questions, responses?
Move through the queue.
I guess we'll just go to the queue then. Yeah. Okay, Santiago, let's just keep going through the next speaker.
Okay,
circle that.
Rob Roy. is our next public commenter. However, he is on a telephone, so I need to identify his line in order to unmute it.
Okay.
I have just unmuted the 805 line. Is this Mr. Robert Roy? If so, please proceed with your public comment.
Thank you, Mr. Avila. Board members, there's been quite a lot of discussion on 20220C. Unfortunately, I'm the reason why, and the case I handled is the reason why this was brought about by the astute observation of Board Member Broad, who saw the inequity of going to complaint over 4 years and 3 months after a ULP charge was filed. I was there in the summer of 1975 doing research on the ALRA. I worked for an organization that negotiated that with Governor Brown and other representatives of the UFW. And it was the idea that we were going to bring peace to the fields and we were going to promote justice for all the parties concerned. And yet today, I have yet to hear one word about the employers in this mix. It's all been about the general counsel can't issue a complaint on a timely basis, yet the NLRB investigators get their cases out on a rather rapid basis and go to complaint. There's a real concern on the part of agricultural employers. I have been here representing employers for going on 46 years. I have been here in Oxnard. I have handled virtually every case that Jessica Arcenega, the prior speaker, spoke about. I probably settled 98% of those cases. I've only had to litigate 2. Right now, I have 10 that are sitting in my office that are over a year old or close to a year old. You know, this is not a problem of trying to track down witnesses or delays. I'm not an employer, a recalcitrant employer trying to delay. Delay means more money for my clients who they may have to pay in a back pay proceeding. So my clients have no incentive to stonewall the ALRB in these investigations. Yet on the other hand, I don't know what the reasons are, staffing, all kinds of other internal administrative reasons, but these cases get delayed. And cases are pending in their office, and yet they jump on new charges coming in. I would assume maybe that increases their statistical data at the end of the year with the legislature. Who knows? But the fact of the matter is that they're dealing with new cases before they're resolving cases that have been sitting around for a year or more. The 4.3 years for Rincon, that's not the only case I've had it in that period of time. My office probably handles the overwhelming majority of charges filed in the entire state of California here in Oxnard over the last probably 10 years, with the exception of the Garawan case. And we move cases along. We have no incentive to delay cases. Barry Broad has made a very astute observation, obviously someone who has a good legal background and understands what we're dealing here. You know, there's a certain amount of justice involved here. We're talking about farm workers' rights, and we're talking about the obligation of the general counsel to represent the state of California. What about the due process rights of the employer that has charges filed against them, and it takes 4 years to go to a hearing, and we can't find witnesses because in this ever-moving industry, as prior witnesses have indicated, have moved on. We lose foremen, we lose soqueros, we lose all the workers, and yet we're forced to litigate cases without having the appropriate facts. As Board Member Broad indicated, he's only saying he's not saying let's adopt latches, although I understand that, and that is probably the general rule that's applicable, but there have been some Court of Appeal cases that have thrown out cases because of substantial delays. So we're really concerned from the employer standpoint. Where do we go with this? There has to be a timeline to issue a complaint. And believe me, as a person who has been litigating before this industry for almost 46 years, there is plenty of time to do the investigations. If, as Jessica Arcenega said, that a worker in the strawberry industry in Oxnard files a charge and then they move up north, well, you know, they've got their telephone number. They can keep track of those people and let them know the investigation is pending. They've got a regional office up in Salinas and up in Santa Rosa, up and down the state, with other board agents that can certainly fill in for a period of time. There's no lack of availability of people to investigate these charges. I think that we have to have a defined period of time to force the agency just to issue a complaint so that an employer in an ever-moving industry has the ability to litigate these cases with facts and witnesses when the facts are predominant in their mind, not 4 years later, not 3 years later. I can't tell you, in a recent case I just did with Judge Sobel, that was another one, Sinagro Farms, that was another 3-year case. And how many witnesses in there were testifying, oh, well, I don't remember, it was too long ago. Of course it was. People aren't going to remember those facts 3 to 4 years or more ago. So, you know, the bottom line here is that I don't think this has to be investigated. You just need to adopt a bright line, 12 months. And bottom line is, if there are extraordinary circumstances that the board's general counsel can demonstrate why they need additional time, then they could make an application to the board and they can demonstrate with facts and how they will be prejudiced or whatever, and let the board make a decision whether they should be allowed a reasonable extension of time, maybe 30 days, maybe 60 days beyond that 12 months. But to get rid of a bright line type of extension like that, I don't think is the appropriate way to go. And you're talking to someone who deals with this thing for the last 46 years of his life. I live this stuff. I'm not talking about what might happen or speculation or farm workers might do this. I'm telling you the reality every single day. And we need something like this in order to give employers a sense of due process and a sense of justice. Thank you.
Thank you, Mr. Roy. I'm unmuting Chair Lightstone and
Thank you. I think we need to, I appreciate the comment. How many more witnesses do we have or commenters do we have in the queue, Santiago?
At this moment, we have 5.
Okay, let's keep moving through them, I think, unless someone has a compelling reason. But let's just in the interest of time, let's urge everyone to be as concise as they can be. That's not a comment on anyone's prior comments. It's just that we have a lot more folks to talk in. So let's move along, and hopefully they'll be focused. Thank you.
Delia Martinez is responding to an earlier comment by Jessica.
Hi, yes, my name is Delia Martinez. I work with the Salinas Agricultural Labor Relations Office in Salinas. I've been with the ALRB for 20 years, serving as a field examiner and as a supervising field examiner. We take our charges very seriously and we work them as quickly as we can. A lot of times, and I agree with everything that my coworkers have said earlier, Michael Marsh, Jessica Arciniega, and Veronica Cervantes and Francesca Herrera. It's very difficult sometimes with workers that are like getting towards the end of the season. So right now here in this area, we have a lot of workers that are concluding the season, and we have issues with when they move, and we have to try to locate them. It's not that easy that we can follow them, and this is where they moved to now, here's their new address, because a lot of the workers don't know where they're going to go. And so that takes time to try to locate workers. In fact, right now I have a case where I was locating a worker, and I found him in Tijuana. And so he's off working for 4 weeks, off in some other ranches where there's no way to communicate with them. So I have a calendar to look for him in 4 weeks. But this is just a little example. So if we have our cases, we work hard to meet with our charging party and their witnesses. A lot of them work. They're working. We don't want them to lose work. And so we work hard to work around their schedule. So you could only have so many interviews or interviews with workers in the evenings. So we have to limit it to 1 evening. And even then it's hard because the workers are, they have families, so they work 9-10 hour days and they get home and they're tired. And so we try to work around their schedules. And so we have a lot of our staff going out and doing interviews in the evenings or on the weekends, whatever it is to get our investigations done. We also do work with employers, and oftentimes they ask us to postpone interviews. So once we get an investigation, we immediately ask for documents that we believe are relevant and for interviews. And oftentimes we're asked to hold off on those and by the employers. And so we try to work around their schedule also because we want to be as the least disruptive to their work. And so that also puts a delay in the investigations. But in my 20 years, I have never, in my experience, I have never delayed an investigation purposely. We work hard to get them done and done quickly and to do the best job that we can. And that's it. That's for my comment. Thank you so much for allowing me to comment.
Thank you, and unmuting you, Chair Lightstone.
Thank you for the comment. Let's go to the next comment. And whoever it is, if the point's been made, you could also just second the prior comments. If we've already heard that point, we're particularly interested in additional or unique thoughts and so on, but thank you.
The next commenter, if he has joined us, is Howard Sagasser. If you have joined the meeting, please unmute yourself and provide public comment at this time. Okay. The next commenter, Ed Haas, unmute yourself and provide comment.
Okay, can you hear me?
Yes.
Okay, so my comment, because it's, I don't know, probably a year, maybe 2 years ago, I did a spreadsheet on how long cases were taking from charge to complaint. And I don't have that spreadsheet in front of me right now, but it seems to me that cases that were like 3-4 years, like we've been talking about, were kind of unusual. They were outliers. So I'm just kind of curious, how often do we see that kind of lengthy delay? I mean, are we talking about something that's really unusual?
You are unmuted, Chair Lightstone. Do you wish to continue or do you want to address?
Does anyone have any questions? Thank you, Ed. Let's keep going. Who's next?
The next commenter is Chris Snyder.
Good morning. First of all, I want to thank the board for being concerned about delays because it's true that justice delayed is justice denied. But justice delayed is better than justice arbitrarily denied because some timeline wasn't met by some state employee. And a worker, a farm worker, doesn't get to have their case resolved. I've been working with farm workers since before the board came into existence. And I was involved in filing unfair labor practices back in the late 1970s. And delay then was already a problem. But what I saw back then was there were cases where the cases were just sitting there for no apparent reason. I actually joined with farm workers in picketing ALRB offices in one regional director's house for taking so long in getting a case investigated where all the workers were available. They were telling that RD that they were available to be interviewed, but for some unknown reason, the case just wasn't moving forward. And it would have been truly unfair if those workers' case would have been dismissed because for whatever reason, that RD had decided not to move that case forward. And I'm not suggesting that would happen today, but there is a history. I think the board needs to be aware of that. And of course, cases we're talking about today, COVID had a huge impact on our ability to investigate. I think that's sort of been ignored. Also, I want to emphasize something Jessica said about people don't all, it's not like we can just look at check stubs and determine whether or not a violation has occurred. We have to investigate much deeper. In my 40 years in dealing with ULP practices, I have only seen one time where the employer wrote out a ticket firing workers saying, "You're fired because you engage in protesting." They usually don't do it that way. They usually don't make it that easy. And for all the reasons that the other staff have talked about that cause delays, I think it's just, I support all those reasons. They're on target. I'm also very concerned that these regs have not been, as far as I'm aware, I may have missed it, but I believe, as far as I know, they haven't been published in Spanish. And the people impacted the most by this are Spanish-speaking workers. And I think there's some, the Daimler Aleatory Act may come in play here. And then finally, I am very concerned, as to my knowledge, the NLRB does not have an arbitrary timeline. But the NLRB also isn't dealing with migratory workers. We do have a lot of migrant farm workers. And what I have observed over the past 40 years of being involved with farm workers is that more and more of the migratory workers are indigenous workers. And I think that if this reg were adopted, it would have a disparate impact on indigenous farm workers. Somewhat ironic, since we just declared our first Indigenous Peoples Day in the United States. So for all of these reasons, I would urge that the board find other ways to promote promise. Thank you.
I'm unmuting you now, Chair Lightstone. Do you wish me to continue to call the comment?
Yes, please do. Thank you, Chris.
Our next public commenter is Brian Little, if he wishes to weigh in now. I know we're not at the very end yet. There's another report, but I want to allow the opportunity to provide your public comment at this time if you wish.
I just wanted to emphasize at the outset that my comments apply to the regulatory package as a whole, not just to any specific piece of it. And I wasn't aware coming in that we were going to be talking about each report individually. So just bear with me. I'm going to be talking about several different features of the regulatory package that are in different parts of the 6 reports, some of which I believe you may have already elected to move forward with, some of which you may, or some of which you may hold till a later time. Anyway, so good morning, Mr. Chairman and members of the board. I'm Brian Little with California Farm Bureau, California's largest organization for farmers and ranchers. We represent everybody in California who grows everything from apples to zucchini. And as a result, California Farm Bureau members employ a great many employees and have a great deal of interest in the activities of the Agricultural Labor Relations Board. I appreciate the opportunity to offer public comments on this package of regulatory changes dealing with various aspects of the board's handling of mandatory mediation and conciliation, unfair labor practice charges, and so forth. I recognize and appreciate that the regulatory subcommittee has held a public listening session on some of these proposed changes. Unfortunately, I was not able to participate in that listening session due to scheduling conflicts. Now that the subcommittee has presented its full report, or I suppose at this time actually in the process of presenting its full report to the board, and the board has elected to proceed with some of it and may elect to proceed with more of it later on today, I'd like to offer some points of concern with the draft regulatory changes released on September 22nd. First, the revisions of the regulations concerning the handling of unfair labor practice charges would allow a regional director to redact the identity of a party lodging an unfair labor practice charge. This decision would be unreviewable. This change raises obvious due process concerns as it denies the accused the opportunity to know the identity of his accuser and to conduct an investigation of the circumstances and present a competent defense against the ULP charge. Another of the proposed changes to the ULP process bars a charged party from later mounting a defense for failure to respond to the initial charge. This is problematic for several reasons. Given the proposal to redact the charging party's identity, the charged party may not have enough information to respond. Given another proposal concerning allowing service to security guards who may not know who or what the ALRB is, what service is, and what to do with it, or who will frequently be employed by a third-party site security consultant, the charged party might not have enough information to make an initial response. And under this revised rule, the charged party therefore forfeits the right to mount any defense, which raises another due process concern. Requirements in these draft regulations requiring employers to furnish mobile phone numbers and emails in employee lists subsequently furnished to a union seeking to conduct organizing raises obvious privacy concerns for employees. Mobile phone numbers can be particularly sensitive given the degree to which the agricultural employee population relies on mobile devices for communication and for other reasons. Some revisions concerning service in the course of the mandatory mediation and conciliation procedure call for response within 5 days. Given that the parties sometimes game the work week to shorten the time available to a respondent, 5 days is far too short. 15 days or 10 days would be much more reasonable. At a minimum, the period for response should be no less than 5 business days to prevent a situation where a weekend will leave a respondent with only 3 days to respond. I thank you for the opportunity to comment, and we are looking forward to participating in the regulatory process as it unfolds. Thank you.
Thank you, Mr. Little. I am now unmuting Chair.
Thank you. Can you hear me, Santiago?
Yes, I can hear you.
Okay. Member Broad has a question for Mr. Little.
Yes, Mr. Little, will you be submitting written comments?
That's my intention at this time, yes.
Okay, because you had a lot of different things, and I just want to make sure we can.
As I said, I didn't realize we're going report by report by report. Otherwise, I would have organized my comments in that way, but
Yeah, well, we apologize if we kind of threw a monkey wrench into the plan. But anyway, we are going to be considering it, so I'd like to get it in writing if we could.
Yes, I intend to do that. Thank you.
Okay, thank you. So Santiago, let's keep going.
At this time, there are no additional public comments. However, on this particular topic, Francesca did express a wish to speak at the very end. I don't know if she wishes to weigh in now or not.
I didn't mean to speak at the very end. I just meant to put my name in the queue whenever it was supposed to be. I have very limited comments, and I'm not going to talk about the 12 months anymore because I think you've heard those arguments quite loud and clear. I just wanted to, I know board member Broad had talked about wanting other ideas on how to move cases forward more quickly. And I think allowing the general counsel some additional discovery tools certainly will allow us to move more quickly. One of the tools proposed in this regulatory package is interrogatories. I think interrogatories are a wonderful idea. They will help us ask targeted questions and probably save employers a lot of time in production. Some of these questions are very targeted. They could be one-word answers, but if you need to ask for them in documents contained by the parties, you might have to craft 3 different document requests to try to find the one document or the one piece of information you're looking for. The one concern I have about the interrogatories is the limited scope. It's limited to the identification of the employer, the identity of the charged party, and the supervisorial status of the players involved in the allegations of the ULP. There are several other topics that could be very useful to allow the general counsel to ask interrogatories. For example, wage rates. I could ask for all payroll for all your ag workers, or I could ask just the wage rates for certain classifications of workers, or I could ask for what the classifications, your classification, an employer's classifications of workers are. It would save them a great deal of time if they could just identify what they call those classifications or what locations they're working at on a certain day, rather than ask for all payroll or all contracts or all invoices to show where you worked during a certain week. So I think the limitations on the interrogatories are too narrow, but I do think interrogatories are a wonderful idea to pursue and will allow us to move our investigations more quickly. Considering other discovery tools also might be a way to allow us to move our investigations more quickly. The only other 2 comments I wanted to make was one, I definitely support being able to redact the charging party's name from charges. Sometimes charging parties do not want to file charges because they are concerned because of immigration status issues, because of the political climate, or just because of a fear of blacklisting from other employers that they've heard employees who complain don't get hired other places. The employers all talk to each other. So there is concerns amongst employees, and I have had cases that are fully litigated and not pending before this board that another worker and another crew decided to file on behalf of certain workers who are very afraid. So that was by happenstance and luck that charge was able to be filed, but sometimes we aren't able to file those charges. And the third thing I just wanted to support was a service on security guards. Serving ULPs and other notices to cannabis operations have been very challenging. I've voiced this concern previously at regional director meetings, and this regulation will help us at least get documents to the right people quickly and more efficiently. So those were my very short comments. Thank you.
Thank you, and I'm now unmuting the chair, and at this time there is no further public comment or no one waiting in the queue unless, and I'll just briefly call it out, Mr. Howard Sagasser, if he has joined us. He can indicate and provide public comment at this time. Okay, doesn't appear that he's joined us, so you are able to proceed.
So.
Okay, so am I unmuted, Santiago?
You are.
Okay, thank you. Well, so that's the end of the queue, at least on this report. I thought it was a very substantive discussion. I appreciate everyone's comments. I think that, I don't know, Member Broad, if you want to renew your motion
Oh,
to,
yes, very definitely.
to further bring
Absolutely.
study the comments and bring this back.
Yes. And I do want everyone to understand that sometimes to get to the answers and things, you need to push the question. And, but I do think that there are some major issues here that we have to look at in terms of this. I think folks have raised on both sides, really, raised very, very significant issues. And that I think we need to look at. And so I would renew my motion that we send this package back to the subcommittee to reconsider and modify as necessary and bring back to the full board.
Second.
Okay, I will call the roll. Member Broad?
Aye.
Member Flores?
Aye.
Member Hall?
Aye.
And Member Lightstone, aye. I think, boy, we have been here a long time. We have one more report, which is the elections subject, I believe.
Chair Lightstone, I'd just like
Yes.
to inform you and the board that the interpreter has a hard stop of 1 p.m. We will lose interpretation services at 1 p.m.
Okay, so let's,
Well, let's see how we do.
let's go, remind us in about 5 minutes, or we'll try and move this along, see if we can get it done. And then we can just wrap up the meeting, I think, so.
Will do.
Okay, so this last proposal deals with elections and representation proceedings. And I won't go into any details, but there are some substantive changes in this, but a lot of technical changes as well. So with that, I will stop and we can
See if there are comments.
see if there are comments.
Are there any comments on this report? How about in the public, Santiago?
There's no one in the queue for public comment.
All right.
Well, I'm wondering if we should, because if people are tired, we're blasting through, if we should put this in the queue to bring back, even though we haven't had any comments, or would you move to just
I'm
move
prepared to
along?
move it.
Okay.
I think people, if they have
Okay.
issues with this, they want to.
Okay, well, they'll have another round in the actual rulemaking when we
Yeah,
proceed. So, okay,
it comes back as a regulation and people are
Okay.
upset by it.
okay, so
All kinds of time to
so
comment.
make your motion and we'll, because we
All
want
right,
to.
so I'll move that we accept this proposal.
Second.
Okay, I'll call the roll. Member Broad?
Aye.
Member Flores?
Aye.
Member Hall?
Aye.
And Member Lightstone, aye. I think that completes the work of going over the report, the subcommittee reports. Now we need to move to the, to wrap up the meeting to the general public comment period. So why don't we, without all the introduction, let's find out if there's any member of the public that wishes to make a general comment on
There is
anything in the
not.
meeting. Okay,
There is no one standing by in the queue at this moment.
okay. Well, then I will dispense with the personnel report because I think that's all been covered. And and under announcements, the next public board and regional directors meeting is Tuesday, December 14th. That's an announcement. Is there any other business to be taken up? Okay, well, I would like to thank everyone for their participation and the interpreter for their help throughout this process. And thank you all very, very much for your patience and your involvement. And with that, I will entertain a motion to adjourn.
So moved.
Okay,
Second.
okay. Member Braun,
Aye.
Member Flores,
Aye.
Member Hall,
Aye.
and Member Lightstone, aye. And this meeting is adjourned. Thank you.